Is People v. Aguilar?
Good afternoon, Your Honors. Jan Hoth for Appellant Gonzalo Aguilar. I'd like to reserve 3 minutes for rebuttal.
Yes.
When a jury asks to rehear all definitions discussed, any response that does not include the definition of justification, which had been previously charged to the jury, cannot be considered meaningful.
In this case, Almodovar, isn't it the same case that's already been decided?
Absolutely not, Your Honor. First of all, in Almodovar, when asked to give the charges, the court sought clarification. Here, the court never sought clarification, so everybody was just basing this on what, as they were reading the note.
But what about the fact that the note, when it said all definitions discussed, it was followed by a listing of the counts, et
Yes,
cetera, et cetera?
and clearly, by listing several of the counts and then adding an et cetera, the jury was meaning to limit their request to all definitions discussed as to the charges. They were making it clear, we don't want to hear reasonable doubt, we don't want to hear presumption of innocence, we want to hear all definitions discussed as to all of the charges.
But what you just said, though, is you editorializing. How do we know? Maybe they did want to hear presumption of innocence or interested witness, or, you know what I mean? Like the et cetera, anyone can fill in what et cetera means.
Right, I mean, I don't disagree, but in that case, all means all, and justification should have been given. So working with the note as the court read it, the court was reading the et cetera and the list of charges to mean they wanted all definitions relevant to the charges.
And they didn't follow, did they follow up with a request for it when it wasn't given?
No, they did not, Your Honor, but taken in context here, this note, just reading this note took the court 4 pages of transcript. There was that many requests in it. But more importantly, the jury asked for all definitions discussed and then listed a couple of cases. So if we work from the assumption that they wanted all definitions discussed as to the charges, they have to believe that that's what the court gave them.
But we work from the assumption that the court is to meaningfully respond, and if the court misses something, there will be another note, if that's what they wanted.
Well, not necessarily. They asked for all. Why aren't they in there assuming they got all, and that by not hearing justification, the court doesn't think it's a relevant definition
So
for
you're
the
saying it
deliberations?
doesn't matter that they didn't seem to express in a subsequent note that they still had a problem because they didn't get justification?
I'm saying that we can always speculate as to what a jury is thinking.
And I understand that. And as a trial judge, your judge's responsibility is to meaningfully respond. Did the note say justification?
No, the
And
notes...
can it be charged separately?
Excuse me, Your
Can
Honor?
justification be given as a charge separate from the other portions?
Well, no. Once the court decides that the defense is made out of justification defense and as here, is going to charge it, it's now part of the charges.
It gave the charge of justification, but when a jury is asking, quite frankly, it can take hours to read a jury instructions. And the jury clearly understands everything they ask for. It's going to take the same time to read it all over again. So they do excise out things they want read back.
But there's no indication in this note that justification, which having been charged to the jury, is now considered an element. It's now something that the people have to disprove beyond a reasonable doubt. Mr. Aguilar was charged with unjustified homicide, unjustified assault, not homicide and assault. So by saying all definitions discussed, putting in a couple of the charges, yes, they're limiting it to the charges, but the charges now include justification.
Let me just ask, sorry, as somebody who's never been a trial judge, let me ask it from a lay perspective almost. I think, or you can correct me if I'm wrong, that when the charges were given here, the counts were read and then justification was read separately. Is that right?
Well, Not separately so much as each count was read and then the court explained justification. So he did not, as my adversary points out, say, and then another element. But they were given justification and told
But
in
there
their
was a
charge.
separate part there where what the components of justification are was laid out. And that wasn't done 9 times. Is that right? It was just done once?
Well, I believe that the actual definition of justification would have been given the first time, and then after each count that it applied to, the court would remind the jury that if they found that the people had proven all of the elements of that count, they then had to decide whether they had disproven beyond a reasonable doubt justification. But that does not segregate, or we could speculate it did, but there's nothing on the record to suggest that that separates out their request when they're asking for charges. By charging the jury with justification, the court made it an element that the people had to disprove. If you're asking for all definitions discussed, you can't exclude justification and say that you've meaningfully responded to a request for all. It's not all.
So I'm trying to see you might be making both arguments, the alternative, I suppose. One would be that so long as justification is given anywhere in a set of charges, because it is a part of the people's burden, it is necessarily incorporated into each, and so the form in which the charges were given doesn't really matter. Automatically, every time that someone asks for any count to be read back, and there's justification that's been given, you have to read the justification defense as well.
Yes, Your Honor.
Is that what you're arguing?
Yes, Your
Okay.
Honor.
So it doesn't matter where or how this is structured?
Yes, Your Honor. I mean, I believe the CJI now actually suggests that the court explain it's another element.
So if the note had said, we would like you to read back count 1.
Yes, and if count
Or
1
count
has a
3.
justification defense, then,
If the justification defense were applicable to count 1, even if it wasn't physically contained in the instructions and the charges the judge read them,
well, no, it has to be,
referenced.
it has to be the defense.
Yeah.
The court has to have charged justification.
Somewhere.
As to count 1.
Right.
And then if the jury comes and says, we want count 1,
Yeah, let me see if I can make this clear. So suppose the court reads, let's make it count 2, but suppose the court reads count 1, right, which are the elements of the crime, and then reads the justification fully, explains justification, and then moves on to count 2, and reads the elements of the crime for count 2, and says, and if you find it's justified, without reading back the elements of justification. Your view is, your argument is, that if all the jury wants is count 2 read back, the judge has to read back the definitions of justification. Okay, I just want to get
Yes.
that clear.
Yes,
Okay,
Your
got
Honor.
it.
So
Yes.
would that be true for any defense?
I'm sorry.
Would that be true for any defense, like insanity, if you ask for
If the
definitions?
defense is one that the people are required to disprove beyond a reasonable doubt, like justification, then yes, it would apply. Because that now, once the court is charging that defense, it's placing the burden on the people to disprove it. So it's adding an element to a crime. They have to prove the elements in the statute, and then they have to disprove beyond a reasonable doubt that the actions were justified. And if I could take a moment, I would like to discuss the interested witness charge here and say that clearly,
Was it preserved?
no, it was not, but as this court has made clear very recently in People v. Cabrera, futility does apply when the legal claims were foreclosed by precedent from this court. And this court, back in 1989, reviewed the question of the appropriateness of charging a jury that the defendant is an interested witness as a matter of law, and found that that was appropriate. That decision has never been questioned in any state court since.
What about the delay here? The appeal, it was delayed a number.
It was delayed an extraordinarily long time, and not through any fault of Mr. Aguilar, which is why the First Department ruled that he could continue with this appeal. I can...
But does that come into play with respect to your suggestion about the futility?
Well, no, the futility existed at the time of his trial, and that's why counsel didn't object to the charge. And it only coming into play now because in 1989, this court said the charge was appropriate.
Okay, so it came into play pursuant to Cabrera? Is that what you're arguing?
No. In 2002, Mr. Aguilar was tried, did not object to the charge. In 2006, the Second Circuit first started ruling that charging a jury that a defendant is an interested witness could create a motive to lie and is an improper charge. 2007, they reiterated. And then in 2019, they went even further.
But that's what I was that's why I was asking you about the passage of time.
Right.
Because there's been such a long time with respect to his appeal. Not that it's necessarily his fault, but just wondering how you would see that impacting the laws changing because there's time
Right.
that's going by, and his appeal is just sitting on the shelf. So would that arguably give someone an incentive to be less than in a hurry to go through the process, hoping that the law will change to their favor?
Well, I think that's quite a wish. I'm sure all defendants hope the law changes in their favor, but they'd be wishing for that sooner rather than later. And I don't think
But you
any...
do concede it's an oddity here that this one took so long.
Well, yes, this is an outlier in how long it took Mr. Aguilar to get his appeal heard. No question about it. But again, I do think it's important that it was not his fault. This is not gamesmanship on his part. And I'd be happy to send the court all the motion papers that we engaged in to gain him this right to appeal.
Let me just ask you quickly to do that math for me. From the time that counsel, if they were aware, would have, under your scenario, would have requested the charge, and when there's a case that would have, again, a counsel in the same position, alerted counsel, I've got an opportunity to request that charge. How much time had passed?
4 years.
4 years, okay.
4 years, yes. It was in 4 years, in 2006 is when the Second Circuit in United States v. Gaines first indicated its disapproval of this charge. And as I've said, as time has passed, it has repeatedly and restricted the charge more and more. Every district court that tries to abide by the previous ruling gets smacked down again. They don't like it in any form whatsoever. And even when, as here, the court says, well, just because that he has an interest in the case doesn't mean you automatically reject his testimony. Second Circuit, even that's not worth it.
But in those Second Circuit cases, they were saying that he had a motive to lie. And I
Yes,
think
but the
that's a
Second
critical
Circuit has also
distinction.
said that it's not dependent on the language used, that what is the troubling aspect in these charges is when the court's charge gives rise to the inference that because the defendant has an interest in the outcome of the case, he has the motive to lie. That clearly undercuts the presumption of innocence because only a guilty defendant has a motive to lie. It's particularly troubling here because this was a credibility contest. We had Mr. Aguilar with his testimony as to what happened, and we had these other witnesses with they were not interested witnesses. They were...
So in this particular instance, did the charge say that the defendant had a motive to testify falsely?
No, it did not use that particular language. It said that he was an interested witness, and the jury was allowed to use that interest in the outcome of the case in assessing his credibility.
Okay, does that matter?
Yes, it does, because that's what the Second Circuit has said, is giving rise to the inference that
So
by
it's
having
an
a motive,
It's an inference regardless of whether the court specifically said
Exactly.
the
That is what the
defendant.
Second Circuit has ultimately come down to, that even regardless of the specific language the court's using, if the upshot inference from that charge is that an interest in the outcome gives you a motive to lie, it's an improper charge.
Thank you.
Thank you.
Good afternoon, and may it please the court, Stephen Kress on behalf of the people. I guess if I can, I'll start with the interested witness charge first, and first address the preservation issue. Cabrera absolutely did not say that there's a futility exception to the preservation rule whenever a claim was foreclosed by precedent from this court. In fact, Cabrera expressly discussed People versus Martin, which is a case that was decided in 1980, shortly after the Supreme Court decided Payton versus New York, which said you can't make a warrantless arrest inside somebody's home without exigent circumstances. The law in New York at the time of the trial in that case said you absolutely could make a warrantless arrest inside the home. It was actually a statute. I mean, the law was absolutely clear this claim was foreclosed, and this court, nonetheless, in Martin, said the claim has to be preserved. Peque is another example, and there are even more. So I actually think Cabrera made clear that that is not an exception to the preservation requirement. So this claim is obviously unpreserved, and the court should not reach it based on some futility exception that just doesn't exist in the case law. Turning to the merits, and I also want to respond to something my adversary said. The Second Circuit, and let me be as clear as I can about this, has never said that this interested witness charge is unconstitutional or unlawful in any way. They've never said that you can't tell a jury that the defendant is an interested witness. And in fact,
Doesn't it seem like a bad idea?
well,
In the sense counsel means it, that is, the people are perfectly able to cross-examine on interest, right, to their heart's content. But when the court gives an instruction, it's sort of like putting a thumb on the scale a little bit. That's the difference.
I don't agree with that, Judge. I think this charge in particular, actually, I think it is designed to benefit the defendant, because there are some jurors who might naturally be inclined to disbelieve a defendant's testimony.
Well, I mean, the charge the federal courts tend to give is, and other courts, I think, is something like you should judge the credibility of the defendant the same way you should judge the credibility of any other witness.
Well, it's actually, if you look at the charge that was recently approved in United States versus Jenkins, and I think this is also tracking the model charge, they say treat the defendant's testimony like you would the testimony of any other interested witness. So they are directly saying that the defendant is an interested witness. So I don't think any court has ever said that that is off limits. In fact, the Supreme Court has said
In
that,
this particular instance, did the charge say you're not required to disbelieve or believe the defendant simply because he is an interested witness?
yes, Your Honor, it does say that, and I believe that is also reflected in the pattern charge. And while I think of it, let me also note that the pattern jury instruction on witness credibility in general was amended in 2021 and now includes a provision saying treat the defendant's testimony like you would the testimony of another witness. So juries are now, or at least in the pattern instruction, should be admonished that way. And if I can just make one more tangential point on this note as well, we were talking about the delay between the filing of the appeal and when this is ultimately being heard. The defendant actually brought a federal habeas proceeding in 2017 where he alleged a violation of his right to a speedy appeal, which has been recognized by the Second Circuit. And one of the factors to consider in that analysis is basically whose fault is it for all of this delay, and the federal court determined that it was the defendant's, like he was at fault for most of the delay in this case simply by inaction. So I will just note that tangentially. And I guess I can respond or turn now to the response to the jury note. So I think if we're going to...
So, counsel, since you correct me if I'm wrong, I understand the note to have said all definitions. It didn't say all counts, all charges, it said all definitions. Why doesn't that get you closer to seeing it the way your adversary argues it, that should mean also justification?
Well, so I think if we're going to start from the presumption that they're asking for the definitions of the crimes, which is I think what my adversary said in her opening argument, then we are exactly in Almodovar. That's what happened in Almodovar, where they said, we want a definition. And it's actually, I think, almost exactly like the hypothetical that Chief Judge Wilson was asking, which they said, we would like the definition for counts 1, 2, and 4. and counts 1 and 2, justification had been charged. The judge asked for clarification. Jury sends a note back with a list of the charges. So they're asking for the elements of the crimes. The judge gives them the elements of the crimes, doesn't mention justification, because here, just like here, it was not charged as an element. They went through all the elements, and the judge said, well, at least in this case, and I think we've done the same way in Almodovar, justification is thereafter charged as a defense. And what this court said was perfectly fine. You didn't have to charge, or it was not error for the judge in that case to not give a supplemental instruction on justification. And so I think we have almost exactly the same facts here.
But there they asked for clarification, so I guess the argument here is, why not ask for clarification? If it's not clear what the jury is asking for, why isn't it incumbent upon a judge to ask for a clarification and then respond accordingly? Do you think this note is open to a different interpretation?
Well, so I will say, I think seeking clarification would have been the most prudent thing to do for the judge here, but that doesn't mean that the approach he took was wrong. And I'll actually point out in People versus Malloy, which is a case we cite in our brief, the court noted in that case that it would have been better to seek clarification, but nonetheless held that the judge had given a meaningful response. And so I think, sure, the judge could have asked for clarification here, but the approach he took was to say, I'm going to give the jury what it seems very clear that they're asking for, which is at least the elements of the crime, and if they want more, they can ask for more. And I think it's perfectly reasonable to err on the side of giving them what you are confident they want, as opposed to giving them too much, because like, as this court said in Malloy, sometimes if you...
Did the judge remind the jury that they could receive more if that answer was insufficient here?
So the judge didn't specifically say that. Prior to, sort of at the end of its initial instructions, the judge said, if you have any questions about the law, send me a note. And then when the judge was responding to this note, he began by reading the note and then said, I'm going to give you, or he then said, I will give those definitions again in a minute. And so I think he's communicating to the jury, I'm going to try to answer your question as best I can. And so I don't think there's any reason for them at that point, after he gives his supplemental instructions, which don't include justification, I don't think there's any reason for them to think, he must not think that justification is, that we wanted it. I think that if they felt that that was something they had included in their definitions or in their note, they would have felt comfortable asking that. This is a very different case from People versus Taylor, for example. I think that's the point I'm trying to make.
Why take the chance, though? Especially, I ask why take the chance because you have to sort of assume that the jury found it sufficient, and not that they thought, well, I guess justification isn't important. But in this case, you have the additional factor that after the jury left, and the judge having not clarified the note, counsel actually said, please charge them on justification, and the court declined that request. I mean, it's like you have a chance, an open door to do it, and you keep saying no. So why isn't the better course just to do that instead of coming here and having an appeal where we have to sort of divine why we got silence from the jury after that charge was given?
So I think People versus Malloy speaks to this, where in that case, the jury asked a question about reasonable doubt, and the judge simply reread his initial instruction on that, and the issue was basically whether the judge should have done something more. And what the court essentially said in that case is more isn't always better. If you instruct the jury on something that they haven't asked for, you might be communicating to them, or you might be suggesting that a particular issue is more important than they might think it is. They might have said, hey, let's assume...
And your adversary's position is by not defining something, you're making that issue seem less important than it actually is.
But
So
I think-
which are we to choose?
Well, I think they'll know what they asked for, or what they wanted to know about in their note. And justification was an important issue in this case. It was the only defense. The defendant testified. It was discussed at length on summation. So if they really wanted to know about it, I think they would ask a question about it. And I think if you go beyond that, let's assume for this or for the sake of argument that the jury in this case hadn't been asking about justification, and they get a justification charge back, and they're saying, wow, we didn't ask for this. The judge must really want us to consider this. I'm not sure why. It could confuse them or distract them. And so I think that's...
Just to be clear on the record, did the judge provide anything else other than the elements of all of the charges? Anything else in response to this note?
He provided the elements of the charges, and I think what you might be alluding to is that within the charges, there were certain terms of art that were used, like intent and things like that. He also provided those definitions. So it's the charges and the definitions of the specific terms used therein.
And there are specific terms in justification, true?
Yes.
And do you know if those were defined?
Yes, I believe when he was giving the justification charge, things like, deadly physical force or something like that.
How
yeah.
about when he was giving the additional charges after the jury note and defining the terms? Are they the same terms that are in justification?
No, I don't believe that, they are. No, I think the ones that are as elements of the crimes are different, if I remember correctly. And I guess I will also just note that prejudice is also a component of this analysis. And so I think even if you were to conclude that the judge got it wrong and misinterpreted the note, there was no prejudice to the defendant here. The judge mentioned at sentencing that he thought the defendant's testimony was incredible, and it really was. I think you could have charged the jury 40 times on justification, and it really wasn't going to matter in this case. I actually think it would have been harmful to the defendant to charge justification again, because the more the jury hears what the elements, or excuse me, what the requirements are of that defense, the less likely they're going to find that the defendant has satisfied it. And unless there are any other questions from the court, I'd ask that the judgment be affirmed.
Thank you.
Your Honors, nowhere in the decision of Almodovar did this court say that the court does not have to charge justification in response to a jury note asking for all counts. It was decided on the unique procedural posture in that counsel only objected after the court had gotten the complete recharge, returned to deliberations, and the court said, well, while you maybe should have given it, bringing the jury back into the courtroom was going to place undue emphasis on justification. That's not what happened here. And in fact, counsel was sandbagged by the court because the court kept saying, I'm going to read all of the elements. Well, justification at that point was an element. Whether the court specifically said it's an element, the point is that once it's introduced, the people have to disprove it the same as they have to prove elements. 3 times the court announced to counsel and the jury that it would be rereading all of the elements. And why would counsel think anything but justification is going to be read? It's part and parcel. He then hears a charge where the court not only rereads every element of the charge, but redefines every legal concept associated with those charges except for justification. And my adversary keeps saying that it's too much. Too much for what? That was the defense. So it's not too much, it's fair. You read all the charges that the prosecution alleged my client committed, and then you read the charge related to his defense. And as far as Malloy goes, that's a simple concept. They asked for a recharge on reasonable doubt. They got the recharge on reasonable doubt, and then the court said, well, since they didn't ask for more, it was okay. But here they didn't get part of what they asked for. Part of what defense counsel, when he realized it was missing, believed they had asked for. The court said they didn't ask for that, but that just makes no sense based on the record. And again, it was a completely different procedural posture. This jury was told they were coming back, that the court was not giving them a full answer to their note. They knew they finished lunch, they're coming back and hearing more from the judge. So having him recharge justification at that point is not placing undue emphasis, it's placing equal emphasis. Here's what the charges are, here's what the defense is. This was a case that came down to credibility, and this also ties directly into the interested witness charge. It was a strict credibility case. Giving a charge that eliminates the defense, it just makes no sense. It is so prejudicial. It's signaling this is what I think all definitions mean, and it doesn't include your defense. And then I'm going to charge the jury that in assessing your credibility, Mr. Defendant, they can consider that you have an interest in the outcome of the case. But none of these other people do. We had 6 witnesses claiming that despite smoking weed, smoking ketamine, drinking, they were chill, they were calm, they were not aggressive. This was all Mr. Aguilar and his friends doing. The jury had every right to assess their claims and Mr. Aguilar's claims under the same standards with the same amount of information, and the court's charge did not do that here. Thank you.
Thank you.